We didn't talk about the Trump case. We haven't in the last 2 days or so. So I want to go to Michael Berry, who's the executive director of the Center for Litigation at the America First Policy Institute. Michael, how are you, sir?
I'm doing great. Thanks for having me on.
Good to talk to you. Thanks for being here. So give us I think we're all pretty up to speed, at least on what the accusations and charges are. I got some more in-depth questions beyond that, but just to make sure we're on the same page here, give us the 30-second pitch of what this trial is about. What's he accused of, and et cetera.
I wish there were a 30-second answer to that, but I'll do my best. It's a bit of a show trial, right? I mean, that's really what's going on here. The easiest way to explain it is this is a bookkeeping error that you or me or any number of people could make, and it's really not even a crime, right? Because the Department of Justice at the federal level looked at this and said it's not a crime. You had other analysts look at this, that the Federal Elections Commission, when they tried to say, well, this is a campaign finance violation, the FEC looked at it and said, no, right, there's nothing here, move on. But, of course, we are entering an election year, so the Manhattan District Attorney, Alvin Bragg, has taken it upon himself to say, oh, no, this is a felony. We must charge President Donald Trump with a felony and hold the trial just months before the election. Oh, and by the way, I need to pull one of the Department of Justice's top prosecutors away from Washington, D.C. to Manhattan in order to hire him and try this case. So it's anybody's guess as to exactly what their theory is, because if you read the charges and then you hear what they're saying in court, they don't match up, right? So they're trying to say that now that this is some sort of conspiracy to steal the 2016 election. So again, your guess is as good as mine, but at the end of the day, what they've actually charged President Trump with is a bookkeeping, a clerical error, and now they're trying to say that that's somehow a felony that was an attempt to steal the 2016 election.
And to be clear, the paying of $130,000 of hush money to Stormy Daniels, that question, is that a campaign expense violation?
No.
That went in front of the FEC, and they chose. Did they make a ruling on it, or did they just say nothing about it?
They didn't make a formal ruling because there was nothing to rule on. They just said this isn't even worth our time. I think it was yesterday. There was a law professor who wrote an opinion. I think it was in the New York Times, even. I mean, of all places, and he said, hush money might be unseemly, but it's legal. Right? It's you are allowed to use money, even campaign money, to pay somebody for what's called a non-disclosure agreement. A non-disclosure agreement is something that you and I and millions of others have probably signed more times in our lives than we want to, but it's part of everyday life to do business in this country.
So what? Okay, so that's the basis, and because what Trump should have written in his ledger hush money payment or something in his New York business records? Like what would Trump have had to have done in order for the Alvin Bragg to admit that it was all on the up and up or something? You know what I mean? Like what would it have to have looked like?
I mean, the real answer to that question is Donald Trump would have had to have withdrawn from the election, right? From running for president. That's pretty much the only thing that he could have done to avoid this. Because that's what the other side is already saying out loud, is that if he weren't running for president, none of this would be happening to him. But I mean, the technical answer is, yeah, I suppose he could have exactly written in his campaign ledger, I am paying this money to keep somebody quiet because I don't want to be publicly humiliated and embarrassed, or something like that, right? So that they could then use that to publicly humiliate and embarrass him, which is exactly the point.
Yeah. Is he denying, or is lawyers denying, that he paid the money?
Yeah, I mean, I don't think we've gotten that far in the trial yet. I think what this is really about is number one, this is not a felony, even if it does rise to the level of a crime. And the evidence of any criminality here is very, very suspect at best, right? So it's not even clear whether there's evidence of a crime. And then even if there is the evidence, any crime that was committed is a misdemeanor whose statute of limitations ran out long ago, right? I mean, years ago. And so the only way that they can shoehorn this in to make it fit is to now try to tie it to the 2016 election to say that it's a campaign finance violation. And, now all of a sudden it rises to the level. So it's like a conspiracy to commit a conspiracy to steal the election. And that's, and if you listen to the legacy media talk about it, it's like they're all acting in concert, which is, again, another easy tell, right, is that they all use the same language. They talk about scheme. They talk about conspiracy. They talk about conspiracy to commit fraud and steal the election. So they're all saying the exact same thing. So they're all working from the same sheet of music.
Sure. What's the statute of limitations for this crime?
That I could not tell you. I'm not a New York licensed attorney, but I mean, typically for something like that, for a low-level misdemeanor, you're talking anywhere from 2 to 4 years is the typical range, right? And again, this happened.
So we're 8 years out.
This was way longer ago than that.
Yeah. So 8 years ago, but the reason they were able to get around that is because of the claim that it was done in the act of committing a different crime, which is the campaign finance violation. That's how they were able to zap it back to life.
Yeah, I mean that's the shoehorning it in, right, to a different crime that would be, if it were actually fit there, then it could possibly rise to the level of a conspiracy to commit this bigger crime. And of course, at the felony level, the statute of limitations is typically much longer. You're talking 10 years or longer.
Okay. But is this jury going to rule on whether a campaign finance violation occurred? That's not they can't answer that question, can they? Aren't they only going to be asked, did he forge his business documents?
Well, I mean, that's
right?
the fascinating thing. You listen to the opening statements yesterday, you'd think that that's what this is about, right? That this is actually about a referendum on the 2016 election, because that's what it sounded like. I mean, I wasn't physically there, but I was able to catch some pieces of the opening statements. And I got to say, by the way, this Judge Merchan, I mean, the way that he's going after President Trump's attorneys is stuff that like it's something that you would see on a sitcom or something like that on TV or in film. Because as an attorney who's practiced for years and I've been in front of more judges than I could count, I don't think I've ever had a judge, dress me down that way, or even my opposing counsel in court. The way that he did, he literally interrupted him and said, "You're losing your credibility. You're losing your credibility," and said it. And obviously now that's all public, so that's going to taint you. Your question was whether he's going to get a fair trial and whether the trial's actually going to be on the facts. I don't know how it's possible for Donald Trump to get a fair trial in Manhattan with number one, just this judge, and number two, with the pool of jurors that exists there, and then number three, with the way that the judge is treating President Trump's attorneys and the gag order. I mean, it's like you could go on. I mean, it's just you can list one thing after another to demonstrate that this is what I would expect to happen in Russia, North Korea, Iran, China, things like that. These show trials, that's I wouldn't be shocked, right? If I'd seen what's happening in this case and you told me, oh, this is in Pyongyang, North Korea, it's like, oh, okay, yeah, that's what happens there. This is the United States of America, and you have a judge, dressing down an attorney, and it's now public, and basically saying you have no credibility. How on earth is a defendant, a criminal defendant in the United States of America, supposed to get a fair trial in a situation like that?
Do you know the exact context of the judge saying you're losing all credibility with the court?
Yeah, he was asking the attorney to give him legal precedent, right? So tell me what authority exists, because they were talking about, and this had to do with the gag order. So again, start with the gag order, which in and of itself I believe is unconstitutional. Okay, I'm a constitutional attorney.
Yeah. So actually, let's start with that. What is a gag order, and what is it normally used for? And how is it used?
A gag order
here?
is typically issued by a court and it's usually issued to everybody involved in the case, both sides, right? Your attorneys, your witnesses, the defendant, the plaintiff, etc. And it's basically nobody say anything about this case, because we don't want to improperly taint the jury. We don't want to air the dirty laundry publicly outside the courtroom. We want to keep everything inside the courtroom, so nobody's allowed to say anything.
Is this a common thing? Do judges do that a lot?
No. I mean, it's usually if it's something highly sensitive, or a lot of times if it's involving just salacious details that is unnecessary for it to get out, or if it involves sensitive, classified information or something like that.
Okay.
And so basically they don't want that information just going out, being public, because in America our court trials are public, so the judge can issue a gag order and basically say nobody talk about this. Now, the difference in this case is the gag order only applies to one side and one side only. It only applies to President Trump and his lawyers. It doesn't apply to Alvin Bragg. It doesn't apply to anyone else involved, to Michael Cohen. It only applies to Donald Trump and his lawyers. And so you've got legal experts on both sides of the political spectrum looking at this thing. How on earth is that fair, right? To basically tell – and remember, in our Constitution, the entire system of criminal justice in this country is set up to ensure that the defendant receives a fair trial, right? You are presumed innocent until you're proven guilty beyond reasonable doubt, the highest legal standard known in the law. And yet to say, well, you're not allowed to talk about the case, you can't. He's like, I don't want you bad mouthing any of the people. And then you see like the witnesses, and then you see what Michael Cohen goes on social media and just goes on a tirade and is name calling and is defaming Donald Trump, and knowing that there's absolutely nothing that Trump can do in response because of this gag order. So that's the backdrop. Okay. So President Trump, of course, is prolific on social media, on the app known as Truth Social, right? But all he did in this instance yesterday, where the judge was trying to decide whether Trump had violated the gag order, is to say that he had reposted something, and I think we're all familiar with the concept of reposting, right? Where you're not creating any new content, you just see something and you can literally just click a little button and it automatically just, it's like a repeater. So the judge was basically saying, well, that violates the gag order, doesn't it? And President Trump's attorney was arguing, no, it doesn't violate the gag order. Reposting something is not the same thing as saying that whatever it is that he was accused to have said. And the judge asked him, what legal precedent, what Supreme Court case says that reposting something isn't violating a gag order? Well, I mean, I don't even know how long Truth Social's been around, maybe 4 or 5 years, right? The concept of reposting hasn't been around that long. There's not going to be any legal precedent.